Hello, my name is Jim Mikowski. I'm an attorney. I've been practicing criminal defense in the state of Michigan for the past 20 years, and I'm considered a subject matter expert with regard to the firearms laws in the state of Michigan and self-defense law in the state of Michigan. Next, we're going to talk about Michigan concealed carry rules and regulations. The key topics we're going to cover in this lesson are a test of your knowledge of Michigan concealed carry law, what the Carry Act provides, the training required, the application process for receiving a permit, the process for approval, denials and how to handle them, requirements for displaying your permit, where carrying is banned or otherwise restricted, Michigan marijuana laws and impact on gun ownership, process for purchasing a handgun in Michigan, the Michigan Self-Defense Act, Michigan Castle Doctrine, the aftermath of a self-defense incident, and a conclusion. Here's a question. How many civilians in Michigan are licensed to carry a loaded firearm in public? About 4,500? Between 25,000 and 30,000? 675,000? Or more than 1 million? The answer is more than 1 million. In 2018, Michigan issued its 1 millionth concealed pistol license, a number that is growing rapidly each month. Over 40% of those licenses were issued in Macomb, Oakland, and Wayne counties. Let's talk about the Michigan Concealed Carry Act. In 2000, the legislature significantly amended Michigan's firearms laws to make Michigan what is known as a shall-issue state. Previously, county gun boards were given considerable discretion to issue concealed pistol permits, and the decision often depended on a showing of need by the applicant, which varied from county to county. Public Act 381, which went into effect on July 1, 2001, changed the procedure so that anyone who met the strict qualifications of the law would receive a concealed pistol permit. Today, thousands of responsible Michigan residents have been issued concealed pistol permits. In December 2015, the law was further amended to eliminate county gun boards entirely, transferring the issuance of permits to county clerks and the Michigan State Police. Subject to certain exceptions, which we will review, a license to carry a concealed pistol issued by the county clerk authorizes the licensee to do all of the following. A, carry a pistol concealed on or about his or her person anywhere in this state, and B, carry a pistol in a vehicle, whether concealed or not concealed, anywhere in this state. The licensing process is handled by the county clerk in each of Michigan's counties. A concealed carry application kit is available from your local county sheriffs, local police agencies, and county clerks. Once issued, a concealed pistol permit allows a person to carry anywhere in the state except where legally prohibited or in the so-called gun-free zones specified in Section 5.0 of the Act. The Act also defines exactly what license holders must do when interacting with law enforcement officers, penalties for carrying under the influence, renewal procedures, and many other topics that we'll cover in this section of class. Let's talk about who is eligible for a Michigan concealed pistol license. The Michigan Concealed Carry Act requires county clerks to issue a permit to any applicant that meets the following criteria. The applicant is 21 years of age. The applicant has resided in Michigan for at least 6 months. The applicant is a citizen or legal resident of the United States. The applicant has successfully taken a gun safety course. We'll review those specific training requirements in a moment. The applicant is not under certain court orders, such as those involving mental disabilities, personal protection orders, legal incapacitation, etc. The applicant does not have a pending felony charge and has never been convicted of a felony or certain misdemeanors within a specified time period, including juvenile convictions. The applicant has not been involuntarily committed due to a mental illness, adjudged insane, guilty but mentally ill, or pled insanity in a criminal case. The applicant does not have a diagnosed mental illness that includes an assessment that the applicant presents a danger to the applicant or others. The applicant has not been dishonorably discharged from the U.S. military. The applicant is not subject to a court order prohibiting the possession of a firearm. And finally, issuing a license to the applicant is not detrimental to the safety of the applicant or to any other individual. A determination under this subdivision must be based on clear and convincing evidence of repeated violations of this act, crimes, personal protection orders or injunctions, or police reports or other clear and convincing evidence of the actions of or statements of the applicant that bear directly on the applicant's ability to carry a concealed pistol. Let's talk about the training required to qualify for a Michigan concealed pistol license. Prior to submitting an application, you'll need to take a pistol training or safety program taught by a certified instructor which meets the requirements for knowledge or training in the safe use and handling of a pistol. The program must consist of at least 5 hours of classroom and 3 hours of instruction on a firing range for a total of 8 hours of instruction, including the following. Classroom requirements are the safe storage, use, and handling of a pistol, including but not limited to safe storage, use, and handling to protect child safety. Ammunition knowledge and the fundamentals of pistol shooting positions, firearms and the law, including civil liability issues and the use of deadly force. This portion must be taught by an attorney or an individual trained in the use of deadly force. Avoiding criminal attack and controlling a violent confrontation, and all laws that apply to carrying a concealed pistol in Michigan. There's also a range requirement where the class must provide at least 3 hours of instruction on a firing range and at least 30 rounds of ammunition fired. Note that no specific course of fire is defined. That will be up to your instructor. Your instructor will provide you with a certificate of completion once you have successfully completed the course. The certificate must contain the printed name and signature of the course instructor and the statement, "This course complies with Section 5J of 1927 PA 37D2. The instructor of your course must be certified by the state of Michigan or by a national organization to teach an 8-hour course as outlined on the previous slide. Concealed pistol application kits. Prior to submitting your paperwork to your county clerk, you'll need to pick up an application kit containing all of the proper paperwork, plus other information. County sheriffs, local police agencies, and county clerks must provide concealed pistol application kits during normal business hours and free of charge to individuals who wish to apply for licenses to carry concealed pistols. Kits will contain each of the following items: a concealed pistol license application form provided by the Director of the Department of State Police, the fingerprint cards required under Section 5B11, written information regarding the procedures involved in obtaining a license to carry a concealed pistol, including information regarding the right to appeal the denial of a license and the form required for that appeal, and written information identifying entities that offer the training required under Section 5B7C. The application approval process. The items to turn into the county clerk in the county in which you live are a completed application, a certificate stating that the applicant has completed the required pistol safety training course. If an applicant does not have a digitized photograph on file with the Michigan Secretary of State, include a passport quality photograph. Pay all applicable fees. For all new applications, there is a $100 application and licensing fee payable to the county clerk. The county clerk will provide you with a receipt which you'll need for the next step. Please note, making a knowingly false statement on a concealed pistol license application is a felony, punishable by up to 4 years in prison, and any CPL issued as a result is void from the time it was issued. After completing the steps above, you must request to have fingerprints taken by your county sheriff or a local police agency if that local police agency provides fingerprinting capability. When requesting fingerprinting, you'll need your receipt from the steps above to confirm you've submitted an application packet. If fingerprinting is performed by your local police agency, you may be required to pay to that local agency a fee of $15. The entity providing fingerprinting services must issue a receipt when fingerprints are taken, so long as the applicant has provided an application receipt. Note that you'll only have 45 days after submitting your application to have fingerprints taken. Otherwise, your application will be considered withdrawn and you'll have to reapply. The entity providing fingerprint services will immediately forward the fingerprints to the Michigan State Police for processing, and the Michigan State Police must immediately forward the fingerprints to the Federal Bureau of Investigation. The county clerk must issue a license or notice of statutory disqualification within 45 days after the date the applicant has classifiable fingerprints taken. If the applicant does not receive a license or a notice of statutory disqualification within 45 days after the date the fingerprint receipt was issued, the receipt will serve as a valid concealed carry license when carried with an official state-issued driver's license or personal identification card. The receipt will remain valid until a license or notice of statutory disqualification is issued by the county clerk. The receipt does not exempt the individual named in the receipt from complying with all applicable laws for the purchase of firearms. Let's talk about application fees. The resident fee for a new license is $100, and a renewal license is $115. The county treasurer shall deposit $26 of each application and licensing fee collected under this section in the concealed pistol licensing fund of that county created in Section 5X. The county treasurer shall forward the balance remaining to the state treasurer. The state treasurer shall deposit the balance of the fee in the general fund to the credit of the Michigan State Police. The Michigan State Police shall use the money received under this act to process the fingerprints and to reimburse the Federal Bureau of Investigation for the costs associated with processing fingerprints submitted under this act. The balance of the money received under this act shall be credited to the Michigan State Police. Application denials. If the clerk denies issuance of a license to carry a concealed pistol, within 5 days they must do the following: inform the applicant in writing of the reasons for the denial, including a statement of the specific and articulable facts supporting the denial and copies of any writings, photographs, records, or other documentary evidence upon which the denial is based. And they must inform the applicant in writing of his or her right to appeal the denial to the circuit court as provided in Section 5D. If the clerk denies issuance of a license to carry a concealed pistol or fails to issue that license as provided in this act, the applicant may appeal the denial or the failure to issue the license to the circuit court in the judicial circuit in which he or she resides. The appeal of the denial or failure to issue a license will be determined by a review of the record for error, except if the denial was based upon grounds specified in Section 5B7N, which is the section of the Act which allows the clerk to deny a license if the clerk believes that the issuance of a license would be detrimental to the safety of the applicant or to any other individual. If that is the reason for denial, a review must be done de novo, which means that no other information may be considered other than the information submitted to the circuit court by the clerk. Witnesses in the hearing shall be sworn, and a jury will not be provided in a hearing under this section. If the court determines that the decision of the county clerk to deny issuance of a license to an applicant was arbitrary and capricious, the court will order the state to pay 1/3 and the county in which the clerk is located to pay 2/3 of the actual costs and actual attorney's fees of the applicant in appealing the denial. If the court determines that an applicant's appeal was frivolous, the court will order the applicant to pay the actual costs and actual attorney's fees of the county clerk in responding to the appeal. Moving or loss of card. If an individual licensed under this act to carry a concealed pistol moves to a different county within this state, his or her license remains valid until it expires or is otherwise suspended or revoked. A license to carry a concealed pistol that is lost, stolen, or defaced may be replaced by the issuing county clerk for a replacement fee of $10. Your license will expire on your birth date, falling between 4 and 5 years of the date of issue. An application to renew a license to carry a concealed pistol may be submitted not more than 6 months before the expiration of the current license. The Michigan State Police Concealed Pistol License Unit began accepting CPL renewal applications by mail and through the online system on November 1, 2018. Those eligible to submit their CPL renewal application online will receive a renewal notice through the U.S. mail from the county clerk that issued their CPL containing a PIN. Once in receipt of the PIN, applicants may proceed to the website to submit their renewal application. CPL holders who receive renewal notices not containing a PIN are not eligible to renew online. However, you may submit a completed CPL renewal application with payment to the MSP CPL unit or renew in person at their county clerk's office. The renewal notice will be sent to the address listed on your prior CPL application and will not be updated through other departments, such as the Secretary of State. Do not rely on receiving a renewal notice as a reminder to renew. If applying through a county clerk's office, the renewal application packets must contain the same information as the original application packet except for the fingerprints. The effective date of the renewal license is the date of expiration of the current license or the date of approval of the renewal, whichever is later, and the date of expiration is the applicant's date of birth, which is not less than 4 years or more than 5 years from the effective date of the license. The applicant must sign the statement on the application certifying that he or she has completed at least 3 hours of review of the required training and has had at least 1 hour of firing range time in the 6 months immediately preceding the renewal application. Please note, if you carry a concealed pistol even 1 day after your license expires, you are committing the offense of carrying a concealed weapon, a felony punishable by up to 5 years in prison. You can and will be charged with a felony. In addition to the fine mentioned above, the lack of a license in your possession allows law enforcement officers to seize your handgun. If you subsequently display your license to an authorized employee of the law enforcement agency that employs the peace officer within 45 days, your handgun will be returned. If you do not display your license within the 45-day period, your handgun is subject to forfeiture. If you are found carrying without your license, the law does offer one out, which we suggest you take. If you ask politely, the law enforcement officer can verify your license status through the Law Enforcement Information Network. If they confirm you are a current license holder, you may still get stuck with the fine above, but your handgun may not be seized. Requirements to notify police. An individual licensed to carry a concealed pistol who is stopped by a police officer, traffic stop or otherwise, while in possession of a pistol must immediately disclose to the police officer that he or she is carrying a concealed pistol either on their person or in their motor vehicle. Handing your concealed carry license to a law enforcement officer along with your driver's license is not considered disclosure. You must immediately and verbally disclose to the officer that you are carrying a firearm. In a recent court case, a license holder was found guilty of violating this provision because he waited 40 seconds to verbally disclose to a police officer that he was carrying a firearm. Immediately means immediately. Failure to immediately inform law enforcement that you are in possession of a firearm carries steep penalties. For a first offense, you'll receive a $500 fine and will lose your permit for 6 months. A second offense carries a $1,000 fine and your permit will be revoked. Because of those steep penalties, our advice is that if you are stopped for a traffic stop or any other reason and you are carrying a firearm, you should retrieve your driver's license and concealed carry license prior to the officer making it to your door and immediately inform the law enforcement officer even before you hand over your licenses to the officer. Literally, the first words you speak to the police officer should be something to the effect, "I am a CPL holder and I am carrying a concealed pistol." If you do not have time to retrieve your licenses first, for example, if you are stopped on the street by a law enforcement officer, you should immediately jump to step 2 and inform the law enforcement officer that you are carrying. In all cases, follow the advice on the next slide. This notification requirement also applies if you are a passenger in a motor vehicle, not just the driver. The Michigan Concealed Carry Law requires that if you have a concealed carry license and you are carrying a firearm during any law enforcement stop, which would include traffic stops or for other reasons, you must immediately and verbally disclose to the law enforcement officer that you are carrying on your body or in your motor vehicle. If you are not currently carrying a firearm, no notice is required. When informing a law enforcement officer that you are carrying a firearm, inform the officer with clear language such as, "I do have a license to carry a firearm, which is in my wallet in my back left pocket, and I am carrying today in a holster on my right hip. What should I do?" Follow the officer's instructions to the letter and be prepared to be temporarily disarmed. If in your vehicle, we'd suggest turning on the dome light before the officer approaches and keep your hands on the steering wheel. At no time should you make any quick movements. If reaching for your wallet, inform the officer of your intent before moving. Let's talk about pistol-free areas. While the possession of a Michigan carry license allows you to carry in many locations, there are also a large number of locations where you may not carry, license or not. Note that the prohibited areas which follow do not include parking areas. It's also important to know that if you are found carrying in any of these pistol-free areas, your firearm may be seized by law enforcement. The following penalties may also be imposed. First offense, state civil infraction with a $500 fine and your license will be suspended for 6 months. A second offense is a 90-day misdemeanor with a $1,000 fine and your license will be revoked. A third and subsequent offense is charged as a 4-year felony with a $5,000 fine and your license will also be revoked. It isn't clear how you'd get to this third violation if your license is revoked after a second violation, but that's the way the law reads. School property and daycare centers. It is unlawful to carry a firearm into a public or private daycare center, public or private child caring agency, or public or private child placing agency. Sports arenas, stadiums, and other venues. It is unlawful to carry a firearm into any sports arena or stadium. It is also unlawful to carry a firearm into an entertainment facility that you know or should know has a seating capacity of 2,500 or more. Carrying firearms where liquor is consumed. It is unlawful to carry or possess a firearm in any tavern where the primary source of income is the sale of alcoholic liquor by the glass consumed on the premises. Note that the Michigan Liquor Control Commission makes no guns signs available to bars and restaurants, but there is no legal requirement that those signs be used. Don't make the mistake of believing that the lack of a sign means that carrying is okay at that location. Houses of worship. It is unlawful to carry a concealed firearm on any property or facility owned by or operated by a church, synagogue, mosque, temple, or other place of worship unless the presiding official or officials allow concealed weapons. Hospitals. It is unlawful to carry a firearm into a hospital. College and university classrooms and dorms. It is unlawful to carry a firearm into a dormitory or a classroom of a community college, or university. Casinos. It is unlawful to carry a firearm in any casino, which also includes the casino parking lot. Courthouses. It is unlawful to carry a firearm into any courtroom, office, or other space used for official court business or by judicial employees unless the chief judge or other person designated by the chief judge has given prior approval consistent with the court's written policy. Post offices. The federal government prohibits firearms in federal facilities, which includes post offices, IRS offices, etc. Violating this prohibition may result in federal charges and imprisonment up to a year. As of July 2015, this prohibition once again includes post office parking lots. In a 2-to-1 vote, the 10th U.S. Circuit Court of Appeals said that a U.S. Postal Service regulation banning firearms on postal property is constitutional, which reversed a lower court ruling from July of 2013 that would have let people keep weapons inside their vehicles in post office parking lots. Other federal facilities. The term federal facility means a building or part thereof owned or leased by the federal government where federal employees are regularly present for the purposes of performing their official duties. This would include federal courthouses, IRS offices, post offices, ranger stations, and other buildings in federal parks. Business and property owner rights. The owner of private real property of any type may prohibit the carrying of concealed firearms on the property under his or her control. The owner must notify you that firearms, and by extension you, are not welcome on the property. That notification can be done verbally, through a posted sign, or through other printed material. No standard exists in the Act to define standard sign parameters. If you remain on the property after being given appropriate notice, you may be charged with trespass. Non-prohibited areas, state parks. The Natural Resources and Environmental Protection Act states that the DNR cannot promulgate or enforce a rule that prohibits a concealed carry license holder from carrying on property under the control of the DNR. National parks. In a change in law which took effect in February of 2010, the regulations governing the possession of firearms in national parks and wildlife refuges were updated to allow individuals who possess a permit to carry a firearm recognized by the state in which the national park or wildlife refuge is located to carry in those locations. However, and this is a big however, that right does not extend to carrying in federal buildings, which, as mentioned earlier, are off limits. So, while you may legally carry in national parks and wildlife refuges, you may not carry in ranger stations or other federal buildings within those parks. Carrying under the influence. Carrying a firearm while under the influence of alcohol or a controlled substance carries significant penalties in the state of Michigan. If you are found carrying with a BAC over .10, you can be imprisoned up to 93 days and your license will be permanently revoked. A BAC between .08 and .10 will result in the revocation of your permit for 3 years, and a BAC between .02 and .08 can result in the revocation of your permit for 1 year. Just as with a driver's license, when you receive a CPL, you have given implied consent to a BAC test when carrying, if a police officer believes you are carrying while under the influence of liquor or drugs. If you refuse, the police can get a warrant to compel a blood draw and your CPL will be suspended or revoked, even if your BAC turns out to be 0.00. If you are carrying a concealed pistol and decide to consume alcohol, you must first secure the pistol in your motor vehicle. The pistol must be locked in the trunk. If the vehicle has no trunk, then the pistol must be unloaded in a container or a compartment separate from the ammunition. Suffice it to say, if you know you are going to drink, you should not carry your firearm. Leave it at home and get a designated driver and designated protector. Michigan marijuana laws. In 2008, Michigan voters elected to legalize marijuana for medicinal purposes, and in 2018 for recreational purposes. The Michigan Medical Marijuana Act contains legal protections for licensees which would seem to guarantee patients the ability to use medical marijuana without abrogating any other civil right, including the right to purchase firearms and acquire a concealed pistol license. That is simply not the case. At the federal level, marijuana is still considered a Schedule I narcotic with no medicinal value. Medical marijuana remains illegal under federal law, and the Form 4473 dealers require a purchaser to complete when buying a firearm specifically asks if the purchaser uses illegal drugs, including medical marijuana. Further, although the BATFE does not go out of its way to enforce firearms prohibitions against medical marijuana patients, it will do so if it is brought to the agency's attention that someone possesses firearms and a medical marijuana license. In fact, agents have been known to come to medical marijuana licensees' houses and demand the licensee dispose of his or her firearms solely because the licensee holds a medical marijuana license. At this time, under federal law, you cannot use medical marijuana and purchase firearms. If a county clerk becomes aware that an applicant for a concealed pistol license holds a medical marijuana license, even if the licensee does not use marijuana, then the clerk will deny the CPL application, and the courts will probably side with the clerk should an appeal be taken. Again, remember that making a knowingly false statement on your concealed pistol license application is a 4-year felony, and the resulting license will be void from date of issuance. The conclusion is do not apply for concealed pistol license if you also hold a medical marijuana card or use marijuana, whether medicinally or recreationally. Let's talk about the steps for purchasing a handgun in Michigan. First, we'll talk about without a valid Michigan concealed pistol license. If the buyer purchases a firearm from a federal firearms licensee, the dealer will run a NICS check and issue an MSP RI-60 pistol sales record that must be submitted to your local police agency within 10 days of purchase. The seller will receive a copy, the buyer will receive a copy, and the third copy must be submitted to your local police agency within 10 days of your purchase. If buyer has no concealed pistol license and wishes to purchase a pistol from a private individual, the buyer must go to a police department and request an MSP RI-10 application and license to purchase a pistol. Upon issuance of such a permit, the buyer will then have 30 days to purchase a handgun. The seller will receive a copy, the buyer will receive a copy, and the third copy must be submitted to your local police agency within 10 days of purchase. With a valid Michigan concealed pistol license, if the buyer purchases a firearm from a federal firearms licensee, the dealer will again run a NICS check and issue an MSP RI-60 pistol sales record. The seller will receive a copy, the buyer will receive a copy, and the third copy must be submitted to your local police agency within 10 days of purchase. If the buyer has a Michigan concealed pistol license and wishes to purchase a firearm from a private individual, he or she will execute a pistol sales record, MSP form RI-60 in triplicate. The seller will receive a copy, the buyer will receive a copy, and the third copy must be submitted to your local police agency within 10 days of purchase. Next, we're going to talk about Michigan's Stand Your Ground law. The Michigan Self-Defense Act, Public Act 309 of 2006, provides an individual who has not or is not engaged in the commission of a crime at the time he or she uses deadly force may use deadly force against another individual anywhere he or she has the legal right to be with no duty to retreat if either of the following applies. The individual honestly and reasonably believes that the use of deadly force is necessary to prevent the imminent sexual assault of himself or herself or of another individual. An individual who has not or is not engaged in the commission of a crime at the time he or she uses force other than deadly force may use force other than deadly force against another individual anywhere he or she has the legal right to be with no duty to retreat if he or she honestly and reasonably believes that the use of that force is necessary to defend himself or herself or another individual from the imminent unlawful use of force by another individual. There are 4 key points. First, is it an honest and reasonable belief? Based upon all the circumstances, did you honestly believe that you or another person was in imminent danger? Would a reasonable person in your position believe that you or another person was in imminent danger? Imminent danger means it must be happening now. A threat to harm someone in the future, even the near future, does not constitute an imminent threat. Death, serious bodily injury, or forcible sexual penetration. You cannot use deadly force to prevent minor injury or to protect property. You can't shoot a car thief. A carjacking might be a different matter altogether, especially if you have children in the car. Necessary means there are no other ways to avoid the danger. If there is any other way to safely and reasonably prevent the death, serious injury, or forcible sexual penetration, then it is not necessary to use deadly force, and you cannot then use deadly force. This includes use of less than deadly force or retreat if you can retreat safely. The amount of force you can use is only that amount of force reasonably necessary to protect yourself or the other from the imminent threat of death, serious bodily injury, or rape. If you can reasonably stop the threat safely by using less than deadly force, you cannot use deadly force. You never shoot to kill. You never shoot to wound. You only shoot to stop an imminent threat to you or another person, and once the threat is repelled, you cannot continue using deadly force. If you are attacked by multiple aggressors, you can use force in self-defense against all of them. However, you cannot use deadly force against any of them unless you honestly and reasonably believe that you are in danger of being killed, seriously injured, or forcibly sexually assaulted by that specific person. Your home, the castle doctrine. In your home, there is no duty to retreat. You still cannot use deadly force to protect property, and you cannot use more force than is reasonably necessary to protect yourself or another. You may also, if necessary, use deadly force to prevent an intruder from entering your home, but not if you can reasonably and safely arrest or repel the intruder by less than deadly force. This applies in your home and within the curtilage of your domicile. Next, we're going to talk about what happens after a self-defense incident takes place. The first thing you need to do is call 911. Tell the 911 operator there's been a self-defense shooting at such and such address, please send help. Then hang up. Keep in mind that a feature of the 911 system is that your call is being recorded as soon as you press the last one. The 911 operator is going to try to keep you on the line until police arrive. Don't do it, just hang up. Next, call the attorney you have already pre-selected to represent you. When the police arrive, say something like, "Officer, I am willing to cooperate, but I am not going to make any statement until my attorney arrives." Say it and then stick to it. Wait as long as it takes for your attorney to arrive. Hopefully, an attorney can make it to the scene of the incident. If not, he or she will meet you at the police station. Regardless of how long it takes, say nothing without first consulting a qualified attorney competent in self-defense law. Anything you say can and will be used against you. The stress and shock can result in factual assertions that do not comport with the evidence, and the stress and shock involved in a self-defense shooting can result in the shooter rambling as a reaction to the trauma. Any statement you make almost certainly will be used against you at trial. If you make a mistake, that can lead to additional charges. Do not assume that if police did not read you your Miranda rights, that you can say anything you want and your attorney will get it thrown out. It doesn't work like that. Do not otherwise resist or obstruct the police officers. Do not destroy, manipulate, or alter evidence. Do not resist if patted down, searched, or handcuffed. Do not resist being taken to the police station. Do consider yourself under arrest, whether or not the police say you are. If in doubt, ask, "Are you requiring me to come with you?" And don't let the police officer get away with less than a yes or no answer. If police say you do not have to go or are not required to go, then respectfully decline to go until your attorney arrives. But if they say you must go or lay hands on you or handcuff you, do not resist. If you are locked up, remember that any telephone calls you make will be recorded and used against you. Do not talk unnecessarily on the phone. Expect to be arrested. Remain calm and let the legal professionals sort out the situation. Keep in mind that when a police officer is involved in a shooting, he isn't even interviewed for 24 to 48 hours. Why? To allow the officer time to calm down and make a coherent statement. Why in the world would you want to do anything different? Next, we are going to review the Michigan Criminal Jury Instruction for use of deadly force in self-defense. If you are forced to defend yourself, a jury will be told the following as a basis of deciding whether the act of self-defense was justified. 1. The defendant claims that he or she acted in lawful self-defense. A person has the right to use force or even take a life to defend himself or herself under certain circumstances. If a person acts in lawful self-defense, that person's actions are justified and he or she is not guilty of the crime. 2. You should consider all the evidence and use the following rules to decide whether the defendant acted in lawful self-defense. Remember to judge the defendant's conduct according to how the circumstances appeared to him or her at the time he or she acted. First, at the time he or she acted, the defendant must have honestly and reasonably believed that he or she was in danger of being killed, seriously injured, or sexually assaulted. If the defendant's belief was honest and reasonable, he or she could act immediately to defend himself or herself, even if it turned out later that he or she was wrong about how much danger he or she was in. In deciding if the defendant's belief was honest and reasonable, you should consider all the circumstances as they appeared to the defendant at the time. Second, a person may not kill or seriously injure another person just to protect himself or herself against what seems like a threat of only minor injury. The defendant must have been afraid of death, serious physical injury, or sexual assault. When you decide if the defendant was afraid of one or more of these, you should consider all the circumstances, the condition of the people involved, including their relative strength, whether the other person was armed with a dangerous weapon or had some other means of injuring the defendant, the nature of the other person's attack or threat, whether the defendant knew about any previous violent acts or threats made by the other person. Third, at the time he or she acted, the defendant must have honestly and reasonably believed that what he or she did was immediately necessary. Under the law, a person may only use as much force as he or she thinks is necessary at the time to protect himself or herself. When you decide whether the amount of force used seemed to be necessary, you may consider whether the defendant knew about any other ways of protecting himself or herself, but you may also consider how the excitement of the moment affected the choice the defendant made. Let's talk about the risks you take if you use a gun, even in legitimate self-defense. Financial aspects. The person you shot or his estate may sue you. Innocent bystanders shot in the altercation may sue you. Homeowners insurance will probably not cover you. You will be forced to pay legal fees for criminal defense and for civil actions, and your ability to escape liability in bankruptcy court will be limited. Conclusion. If you shoot someone, even in self-defense, you put your personal future, your home, and your family's financial security in great peril. That's why if there is any other way that you and your family can escape the threat of death, serious injury, or sexual assault without pulling that trigger, don't shoot. Let's go over the topics we just discussed in this section. First, we tested your knowledge on the Michigan concealed carry law. We discussed what the Carry Act provided. We discussed training, the application process for a concealed pistol license, the approval process, denials and how to handle them, requirements for displaying your permit, where carrying is banned or otherwise restricted, Michigan marijuana laws and impact on gun ownership, the process for purchasing a handgun in Michigan, the Michigan Self-Defense Act, the Michigan Castle Doctrine, the aftermath of a self-defense incident, and our conclusions. The use of force continuum. This diagram provides examples of different types of force and the level of force that they might be viewed under. It also shows the rules that must typically be followed and the types of crimes you might be charged with if the rules aren't followed. Let's take a look at reasonable force. Although laws vary, most states will define reasonable force as the minimum level of force required to end a threat, without going beyond that level. Said another way, reasonable force can be thought of as a level of force that does not exceed the threat. For example, if a threat to you included the possibility that you'd be bruised or receive a bloody nose, it wouldn't be considered reasonable for you to respond with a level of force that could break bones or permanently disfigure your attacker. On the use of force continuum, you'll notice that we've extended the reasonable force bar all the way to the right, overlapping with the deadly force bar. That's because regardless of what level of force you use to stop a threat, up to and including using deadly force, you'll need to prove that the force you used was reasonable for the circumstances. Now let's talk about deadly force. Each state's laws also define when it is permissible to use what is generally referred to as deadly force, lethal force, or the justifiable taking of a life. To simplify this topic, we'll refer to this level of force as deadly force. While specific state laws vary, a common standard for the use of deadly force exists, which is deadly force may only be used when there is an immediate and unavoidable danger of death or great grave bodily harm to an innocent person where no other option exists other than the use of deadly force. As simple as that statement may sound, each state will provide further legal definitions or interpretations for each component of that statement, including what it means to be innocent, what immediate means, and what great or grave bodily harm means. After any use of deadly force, the prosecutor and/or jury will get a chance to determine whether or not they agree with your interpretation of those definitions. And, of course, they'll get to conduct their thought experiment over the course of hours or days, and in the relative safety of a courtroom, while you'll need to make your decision in seconds while under attack. Now let's talk about the rules governing the use of deadly force outside of the home. First, you must be in immediate fear of death or great grave bodily harm for yourself or another person. The threat must be immediate and must be so serious that a reasonable person would have also feared for death or great grave bodily harm in the same circumstances. Great or grave bodily harm is a significant or life-threatening injury. Next, you must be an innocent party. You cannot be seen as the person who started or escalated the conflict. Next, no lesser force is sufficient or available to stop the threat. In other words, if you have the skills or tools at your immediate disposal which can stop the threat without escalating to deadly force, then you must choose those alternatives. Finally, you must have no reasonable means of retreat or escape. If you can escape, you must. However, you are not required to place yourself or a loved one in greater danger by retreating. The obligation to retreat has been removed in a number of states through enhanced castle doctrine or stand your ground laws. However, it is your obligation to understand your rights and obligations under your state's laws. Now let's talk about the use of deadly force. First, you must reasonably be in immediate fear of death or great grave bodily harm for yourself or another person. What it usually means is that you must pass the reasonable person test. The prosecutor must agree that a reasonable person would have also felt that he or she would have been in immediate fear of death or great grave bodily harm in the same situation. This rule applies whether protecting yourself or another person. The threat must be immediate. The attacker must have the immediate means and opportunity to carry out his threat. A verbal threat to injure or kill you is not enough. Great or grave bodily harm is a legal measurement that implies injuries so great that death is likely or possible, or that you'll be disfigured or crippled permanently or for a significant period of time. The condition of the victim also matters. For example, in most cases, if a smaller man is punching a larger man in the chest, it would not be considered great grave bodily harm. However, if the larger man had a pacemaker, the criteria might be met, even though the attacker had no knowledge of the condition. What it usually doesn't mean, it is not necessary that the attackers have a weapon. Depending on the relative number and/or the strength of the attackers and the victim, what would be called disparity of force, the measurement of great grave bodily harm might be met even though the attacker is unarmed. Distance is not critical. If you cannot escape, you are not required to wait until an attacker is close enough to injure or kill you before you are authorized to use deadly force. So what does it mean to reasonably be in immediate fear of death or great or grave bodily harm for yourself or another person? Now, we had mentioned that you must be an innocent party. What does that mean? In a deadly force situation, you must be the innocent party. You cannot be seen as the aggressor. That is, you must not be viewed as the person who started or escalated the conflict. Shoving someone at a bar obviously violates this rule. But how about flipping someone off on the freeway? If the situation escalates, don't be so sure what the prosecutor will think. The prosecutor will not only analyze the timeline of the incident itself, he or she will also want to go back in time before the incident occurred to understand whether or not you knew the attacker, whether there was bad blood between you, and if there are any witnesses or evidence, prior arrests, etc., to suggest that you're not as innocent as you claim to be. Now, what being an innocent party doesn't usually mean is it doesn't mean that you're barred from everyday disagreements, but it does mean that if you see the situation escalating, you must disengage, allowing the situation to de-escalate. You are not barred for coming to the defense of another person, but unless you can clearly identify who is the attacker and who is the innocent victim, a prudent course of action would be to call 911 and be a good witness. Don't assume that the guy who has the upper hand in the fight is the bad guy. We mentioned earlier that no lesser force is sufficient or available to stop the threat. What does that mean? What it usually means is if you can stop a threat with something less than deadly force, you are required to. For example, if a reasonable person would have expected that you could have stopped an attack with your hands or the pepper spray that you chose to carry, the prosecutor may not agree that deadly force was authorized. You are required to stop using deadly force as soon as the threat of death or great grave bodily harm has ended. For example, if 3 bullets stop an attack, the 4th bullet could be considered a crime. Relative size and strength of the attackers and or victims matter. For example, a large man being attacked by an unarmed, much smaller woman may have lesser force alternatives rather than resorting to deadly force. In the reverse scenario, the disparity of force may mean that the similar woman might have no alternative other than immediately resorting to deadly force. What it usually doesn't mean is that you are not required to try other methods before using deadly force. You are simply expected to consider alternatives and to only use deadly force when no other option is available or sufficient. Now let's discuss what reasonable means in terms of retreat or escape. What it usually means are that state laws require that if you can do so safely, you are expected to seek escape from a potential attack if an avenue of escape is available and practical before standing your ground and defending yourself with deadly force. Reasons for an inability to retreat or escape can include the attacker has physical control over you and you are simply unable to escape. The attacker is already too close and you have no ability to outrun them. The attacker has a firearm and it would be impossible to try to outrun the bullet. Or you are in a location which offers no ability to escape, such as a room where the attacker is blocking the exit. The obligation to retreat never ends. For example, if you are able to wound an attacker such that it opens up an opportunity to escape safely, you must retreat at that point. The duty to retreat or escape doesn't mean that you are required to go from a bad situation to a worse one. For example, if your only means of retreat is across a busy road, you are not expected to put yourself in greater danger by retreating. Also, you are not expected to retreat and leave behind a companion in the dangerous situation. That is, if you can outrun the attacker, you are not expected to do so if it means leaving a companion behind. Now, the obligation to retreat has been removed in a number of states through enhanced castle doctrine or stand your ground laws. However, it is your obligation to understand your rights and obligations under your state's laws.